what is the legal position? And I ask you this because there's a degree of confusion over whether the Gujarat government has contradicted the centre's own guidelines. And if we just pull up that graphic for the benefit of our viewers, the question is whether the Gujarat government and the central government are on the same page. Earlier this year, the centre actually released new guidelines for special prisoner release or remission. But under this, Vrinda, as you would know, rape was among the heinous crimes that was excluded from those convicts who can ask for early release. And there were other crimes listed as well, including terrorism, the POCSO Act, hijacking, and so on. These are all excluded from the ambit of special prisoner release or remission. So I have to ask you legally, is the Gujarat government in contradiction of the Home Ministry's guidelines? What's actually going on here legally?
So let's see, what does the law say? The law says that the chapter from section 432 onwards deals with remission. It is an important part of any penal system where the state should have the power to allow release. And here also they've been released after 14 years. We must put that on record. Under section 435, if a case has been investigated by the CBI, this particular case was investigated by the CBI. Section 435 of the Code of Criminal Procedure deals specifically with cases investigated by the CBI, and it says that the power of remission that is awarded to the state government in a case investigated by the CBI shall not be exercised by the state government except after consultation with the central government. So when I say state here, I mean the state of Gujarat, the government of Gujarat, as well as the central government. This decision could not have been taken and to reward them with remission except with the mandatory consultation with the central government and therefore the Ministry of Home Affairs. The Ministry of Home Affairs has put out these guidelines. Even in the new circulars issued for release of prisoners on 15th August 2022 as well as 15th August 2023, the Ministry of Home Affairs is very categorical that rape convicts will not get the benefit of this policy. Let us also then look at the law. What does the law say? There is a judgment. These accused men had gone to the Supreme Court. The Supreme Court had said, and this is a law for long, that the policy that will apply will be the policy that was in place at the time of conviction. This conviction for the first time takes place in Bombay, where, if we recall, the trial had to be transferred as there was no hope of a fair trial in the state of Gujarat. The Supreme Court transferred the trial. The Bombay Sessions Court convicted these men in 2008. The policy of remission, which is the state of Gujarat policy, applicable on them, is a policy which dates back to 1992. To the best of my knowledge, that policy is nowhere available in the public domain today. And perhaps the state of Gujarat would be kind enough as a state to inform us as citizens by putting up that 1992 policy under which this remission has been granted.
Can I ask you something? Can I ask you something? I just want to make this simple for the audience that doesn't really understand the intricacies of law. I was under the impression till I started speaking to you that the Gujarat government and the central government were contradicting each other. You're actually saying that these guidelines that have come this summer that actually propose prisoner release, early prisoner release, but exclude crimes like rape are new. And that in your understanding, under the old law, Gujarat could not have released these 11 men without the specific approval of the centre. Am I understanding you correctly?
Yes, Section 435 of the Code of Criminal Procedure, because this particular incident, crime, was investigated by the CBI. Therefore, Section 435 CRPC comes into play, which, and I read again, that the powers conferred to remit or compute a sentence to the state government shall not be exercised by the state government except after consultation with the central government. So the central government has endorsed, approved, affirmed this remission The same central government which puts out a policy saying no rape convict is to be enlarged on remission.
So, in other words, it isn't Gujarat that has contradicted the center, it is the center that has contradicted the center.
The center that has betrayed the women of this country, yes.
So, I'm just going to recap this simply. You are saying that the law specifically says that Gujarat's government could not have released these 11 men seen distributing sweets outside prison today without the approval of the center, the same center that just recently proposed that rape be the crime excluded from the ambit of such special releases. So how can the center hold both views? It's confusing.
It's not confusing. I think that's why it would be. So let me just make this a little clearer. There is a 1992 policy which is not in the public domain, at least not to my knowledge. It may be with others, which would govern the remission. I don't know what is written in it. Most remission policies, I have had the occasion to appear in a matter relating to Rajasthan, exclude heinous crimes, grave crimes. This particular incident is what would, in international criminal law, be described as crimes against humanity when this kind of targeting and killing and gang rape takes place. So any policy would actually exclude heinous crimes of this nature. Because it is CBI investigated, the state government, which is the state of Gujarat, which would apply the 1992 policy, cannot take this decision exclusively by itself. The Code of Criminal Procedure, which is the ordinary law of the land and whose writ will run, compels them to take this decision after consultation with the central government. Of course, they also have to take the opinion of the sitting judge who convicted, etc. None of those documents are before us. We don't know how this decision was arrived at, but the law is very clear and there's no confusion. Therefore, this is not something that the center can say, I have no role to play. We don't know what the state of Gujarat does. State of Gujarat has taken this and you can't shirk. You have approved, affirmed this decision. Your consultation was mandatory. And therefore, for the center to then say that they have no role to play in this would be contrary to the law. And what does the law say? Let me read out further from another judgment of April 2022 of the Honorable Supreme Court. It says, while a discretion vests with the government to suspend or remit the sentence, the executive power cannot be exercised arbitrarily. The prerogative of the executive is subject to the rule of law and fairness in state action embodied in Article 14 of the Constitution. This court has held that the power of remission cannot be exercised arbitrarily. The decision to grant remission should be informed, fair, and reasonable. So simply because you have a power, you don't get to exercise it arbitrarily. And I don't know whether arbitrariness even covers what this remission has actually resulted in. And this particular decision is subject to judicial review. It can be challenged in a court of law, and a court of law can see whether this decision is fair, just, reasonable, or whether the state has abused the power and the discretion that was awarded to it.